Hey, everybody, and welcome. Thank you so much for joining me here today. I appreciate having you here. And we're going to go ahead and get started with this AMA. It's great to see all of you. And I have just a few slides today. Normally, when I do webinars, I have a bunch of materials, but due to the situation of life, we just decided that we would throw in an AMA and see what's top of mind for you so that I can answer questions today. So this is an Ask Me Anything about immigration, and it is wonderful to have you here with me today. You are welcome to start putting your questions in the Q&A panel. Just some housekeeping before we get started. We're scheduled for an hour. I do have a hard stop. I'll try to answer whatever questions I can. This is being recorded. And this is not like a confidential lawyer consultation. So just please keep that in mind. So in the Q&A panel, if you want to ask a question, there's a way for you to choose to be anonymous when you're asking your questions. So I would highly encourage that, especially if you're asking any personal case specific details. And then please also just keep in mind that what I'm able to share with you today is not legal advice. It's just a general overview. And for me to actually advise you on your situation, I need to speak to you one-on-one. And we have a protocol for that where you can reach out to us through Alcorn Immigration Law and let us know your questions. And I do really like the Zoom Q&A panel. And I see that people are already started putting questions in there, which is awesome. So thank you so much. That's a lot easier for me to look at and manage than the chat window. So please, if you do have questions, put them in the Q&A because that'll help me a lot. Okay, so just a few quick notes before we dive into answering your questions. Our mission at Alcorn Immigration Law is really to help people and make the world a better place by allowing people to be where they need to be in their work in their flow states and operate at their highest potential. Because when you can do that, then automatically the world benefits. So it's an honor to be here with you all today. And our mission for the firm is to overcome borders, expand opportunity, and connect the world by practicing compassionate, creative, and cutting-edge immigration law in service of the betterment of humanity. So hopefully the answers that I'm able to provide to you here today will help you to that end, whether you are an employer, whether you are an immigrant, whether you are a person who is outside of the US looking to come here for the first time. You're in the right place. Anything about immigration, I am happy to do my best to answer for you today. By way of background, my name is Sophie Alcorn. I am the founder of Alcorn Immigration Law. We are based in Palo Alto, California, in the heart of Silicon Valley. I have a podcast. It's called the Sophie Alcorn Podcast. I release episodes weekly, and there are a lot of really interesting conversations that I like to have with really smart people. I do some episodes on immigration. I've done over 200 episodes. And so there's a lot of episodes in there on immigration primers. So if you're looking to listen oh, hello, Alcorn team. If you're looking to listen to the past episode library, there's a wealth of information in there for you to use. Additionally, all of my TechCrunch columns are available on our website. So that was hundreds of columns where I wrote about all sorts of immigration topics, and that's all available for you. And how I got into this, my dad was an immigration lawyer. My mom's from Germany. I founded my law firm in my kitchen 10 years. This is like the 10-year founding. H-1B season, oh my God. H-1B season 2015 was literally the first cases I did after 4 years of being a stay-at-home mom when my kids were 1 and 4 years old in my Mountain View home. And my dad had been an immigration lawyer. After he passed away, I decided to start my own law firm to carry on his work. And we've helped over God, probably close to at least 5,000 people over the last 10 years at this point. So it's super rewarding. I get to meet the world's most brilliant people, awesome, kind, energetic, hopeful, excited people who, want to live and create and be open and disrupt things. And I love that founder energy, that Silicon Valley energy. And so it's an honor to support people in this ecosystem. Okay, so before we get to the Q&A, I just want to re-note here for anybody new, feel free to ask your questions as anonymous, because they are shared publicly. Please don't share any sensitive or personal information. This is not a privileged discussion where it's confidential, where you're getting legal advice. This is educational nature only. And wherever you see the QR codes, that's to our firm if you want to book a consultation. We have lots of resources for you. You can always email us, hello@alcorn.law. Our website has a ton of resources. I've worked really hard to curate that over the years. And of course, by phone. And then I do just ask to not put any questions in the webinar chat, and please put them in the Q&A panel, because that is where I'm going to be focusing on for this AMA. In addition to the TechCrunch articles on the website, as well as the podcast, another resource that I offer is my book. It's available on Amazon and Audible. It's called Ask Sophie, the Founder's Guide to Visas and Green Cards. And that is another resource that's available for you. I think it's like $10 on Amazon. And it's available on Kindle or by paperback. And I put a lot of thought and effort into writing that book. So it has a lot of other useful information as well. And I tried to make it different from the stuff that's on my website, just so you know. Okay, cool. So with that, we are going to now see. Go back to this slide. Okay, great. So now I'm gonna be delighted to answer your questions. Okay, so here we go. And I'm just gonna take these in order. We have plenty of time. If you have follow-up questions, that's great. For now, I'll try to spend about 1 to 4 minutes per question, trying to make sure we have ample time for these questions and also any follow-up questions. Okay, so our first question is, hey, Sophie, is the EB-2 NIW harder to get for software developers in banking? Will research papers without citations help? Thanks. Okay, thank you so much for asking that question. I really appreciate it. Banking is kind of a tough industry because it's so secretive and there's so many compliance requirements and everything is so confidential. So often, even for people who are like super, super duper awesome, who've led really critical things, it can be hard in an industry that's super closed off like banking to be able to get sufficient evidence. Additionally, for the national interest waiver green card, because the EB-2 basically is a green card for people with master's degrees or 5 years of experience or exceptional ability, which is easier than O-1 extraordinary ability. But the whole point of the EB-2 NIW and a case that really drives the EB-2 NIW law called Danisar is that we have to show that you are going to help America in the future. And that is why you don't have to go through the perm process with an employer in order to get your EB-2 green card. So basically, it's like, what's the job you're going to be doing in the future? Why are you specifically good at doing this job? Why should nobody else specifically do this job? And what the trends that we've been seeing in the last year for NIW, because there were a lot of people, a lot of corporate NIW sponsorships based on President Biden's executive AI order, the end of the ZERP era, and the tech layoffs. USCIS didn't like all those employers filing EB-2 NIWs for their employees. They're like, hey, you should just go through the perm process. If you laid people off, it's your problem. You should find Americans if you need to hire people. So there was a lot of RFEs in 2024 in the field for EB-2 NIWs. Now there are still RFEs, but we are seeing approvals, but there is new EB-2 NIW guidance that makes it more specific that, and they kind of like created some new requirements that I don't think are necessarily contemplated in the statute or the Danisar case, but they really are wanting to see that you're already doing the job that you intend to be doing. So I used to be able to get EB-2 and IWs approved for founders with a business plan based on starting their company after their EB-2 and IW gets approved, but now I'm recommending that literally you should already be doing the job you want to be doing after your green card, and that has to be the job that's in the national interest. So for banking, if you're a software developer in banking and you want an EB-2 and IW, and now we need to show that you currently need to be doing the job you think is NIW qualified, that means that if you're on an H-1B, it has to be based on your current job. And if you're on OPT, you could already initiate side projects, whether they're experimental or a startup, for example, to show how you're going to be working in the future. And if you're in some other status and you want to do something besides your day job, then you might need a concurrent visa or another visa to be able to do that type of work before you file your EB-2 and IW. So anything is possible, but I would say, like, you know, microfinance for, for military vets becoming entrepreneurs and helping them with their banking by developing software, like that would be more compelling than potentially creating like security software for an established top bank, for example. But research papers can certainly help. They don't need to have citations, but we really have to think about like why this job is special, why it's super critical, why you're really good at it. And then we need to show that track record of your evidence. So I hope that's a helpful overview of EB-2 and IW and where it's going, and also answers your question. Next up, can you do an internship during your OPT, even if they only offer a stipend as compensation? Yes, OPT is extremely flexible. You can be maintaining OPT status even simply through volunteering. You do not need to have a paid job, and it does not have to be either hourly or salaried. You can get a stipend, you can be paid as a 1099 contractor for your consulting work. So there's a lot of different ways to do it. You want to make sure that it matches up with your degree and what you've studied. You need to get the I-20 approved by your school, and you have to make sure you're updating your records in CVIS. And there's different options in CVIS. I'm not privy to the CVIS system, only the universities are and the students are. So I can't see all the options in there, but I know there's an option for self-employed. So you just carefully consider the right button to click there to make sure that all of your I's are dotted and your T's are crossed. Okay. Can I please talk a bit more about the new J-1 STEM research visa? Sure, if I know what that is. J-1s have been around for a really long time. There are J-1s for summer camp counselors and au pairs. There are also J-1s for interns for 12 months after you graduate college, 18 months for training purposes, and 5 years as a researcher. Different organizations are certified to be able to issue the J-1 paperwork. So universities offer it, as well as private, usually nonprofit organizations that have gotten certified with the State Department to become a J-1 host organization. There is a such thing as the 2-year 212E foreign residency requirement, where if the research program involves government funding, such as a Fulbright scholarship, then or a shortage of skills in your home country, because it is an exchange visa to facilitate cultural and information exchange between two countries. So there is a way that people might be required to go back home for 2 years after their program ends in the US. The STEM list changed the The country list changed in December, so a bunch of countries no longer have their citizens automatically need to be subject to that list. The thing that I have talked to a couple of people about this week, which maybe you're one of them, but you're anonymous, so I have no idea. I learned there's a new really cool thing that universities can do for research J1s, and I haven't had any universities try it yet, but I would love to work with you and your university if this is something, and your employer if this is something you want to try to facilitate. The basic idea is, if you do a J1 postdoc at a university for 1 or 2 years and you get a J1 STEM researcher visa at the university, and the US has issued you a DS 2019 form to be an employee of the university and do your postdoc, and then your postdoc ends, and then you want to continue doing research in private industry, let's say, down the street in Silicon Valley or whatever, for a private company that wants to put you on payroll, instead of needing the employer to sponsor you for a new J1 or an O-1 or an H-1B, I learned this week that literally the university can issue a new DS 2019 that says this person is now going to continue doing their J1 STEM research visa at this third-party employer who will pay them directly. And that is a way to authorize further research. And the main thing is the research exchange. So as long as the university can confirm that you're researching stuff and sharing your ideas between your country and America through your research, then that's enough to get it approved. So it's super exciting, and I hope more people do it. And I don't make any money from that. I make less money from that, but I think it's better for the world. So I'm happy to help. So let me know if you need help on that. Has the number of RFEs gone up for O1 and H-1B especially have the RFEs gone up for O1s and H-1Bs, specifically for founders, since the new administration took office? It's a great question. In our experience at Alcorn Immigration Law, no. We've gotten O1s approved, no RFEs, and H-1Bs have continued. It's very different from Trump 1.0, where H-1Bs were the first thing to change. There have been a lot of H-1B changes anyway with the H-1B modernization rule on January 17th. And I'm anticipating that the H-1B stuff is going to shake out more after the lottery happens in a couple of weeks. And then we do the then we prepare the petitions for filing in Q2. I will say, though, that we have seen an uptick in RFEs for EB1As and EB2 NIWs, but that continues the trend from 2024. Please share details about the requirements of the O1 visa. Well, the O1 visa is a visa for extraordinary ability in the O1A visa is a visa for extraordinary ability in the sciences, business, engineering. There's a different version, the O1B, for people with extraordinary ability in the arts or exceptional ability in the motion picture or TV industry. People like the O1 because it's typically a 3-year petition and a 3-year visa for most countries, except if you are a citizen of China, you get single entry 3-month visas. But for most people in the world, you get 3 to 5-year visas with multiple entries. They changed it in December. So now instead of 1-year extensions, there's a way for us to get 3-year extensions. And we've been able to do that since January for multiple clients, which is very exciting. Makes such a huge difference in our clients' lives if they have 3 years instead of 1 year, especially after they've put down roots here. And in order to qualify, you need somebody to sponsor you. The sponsor can either be an employer who's offering you a job or an agent who is representing you and your work. And the petition usually takes us 10 to 12 weeks to put everything together. It's very comprehensive. There's probably 30 to 40 pages of government forms, multiple employer support letters and attorney letters. There's also usually, we do it with 4 to 6 letters of recommendation. And what we're trying to prove is you meet at least 3 out of the 8 categories to prove that you are one of the top people in your field or your subfield in a country or in the world. So we get O1s for founders, inventors, TikTok influencers, all sorts of people, museum curators. It cuts across every profession. It doesn't matter what your experience is in. It doesn't matter if you ever graduated from college. You don't need a Nobel Prize. You don't need a 10 million funded Sequoia startup or whatever. So it's very flexible. We just have to prove 3 out of the 8 criteria and that you're good at what you do. And some of the examples are, did you win prizes? Are you a member of groups that are hard to get into? Did people write about you or your work? What have you created that's new in your field? Do you have a leading or critical or essential role at a distinguished organization? Did you make a lot of money? Did you write stuff? Were you the judge of other people's work? And often our clients have evidence that doesn't fit into any of those buckets. They were on podcasts, or they have viral YouTube videos, or I don't know, they have their own podcast or something. So they give talks at conferences. So it's important to tell us all of that, because we can figure out the right ways to weave it in to the petition. And we send it to USCIS, and then there's 15 business day premium processing, which more literally means 3 calendar weeks. And then most of our clients in the US prefer a change of status. And if you're outside of the US, then you go to a visa interview to get your O-1 visa stamp and come in. That's the O-1, and it's a quasi-dual intent status. So we've had many clients over the years get green cards, although it's technically a non-immigrant visa, but we are being more strict about that in this Trump 2.0 environment. Okay, next question. What should a software engineer or founder do about an advisory opinion from a peer group? Is there a peer group for them? There's not a peer group for them, but we have ways to deal with this, and that is how we get O-1s for founders approved. So we would be delighted to help you, and we bake it into the letter of recommendation process. We have a way to handle that. Next question. Yes, this is recorded and you will have access later. Okay, we're concerning the H-1B. What is the correct order? Raising funds and incorporating before applying for the H-1B transfer, or vice versa? I'm aware that for an H-1B transfer, proof of funding for my salary and my employees is needed, but it is also true I must be in an appropriate status to raise funds. How does the processing time on both the firm and the government sides affect the process? Lastly, how soon can I start working after the filing? Thanks. Great question. It's complicated, and it's different in everybody's situation. There's no there is no one size fits all thing here. So first of all, for new startup, it takes us 6 weeks to get an H-1B filed. It's really hard to do it any faster, because there's a lot of steps we need to go through with the Department of Labor, making sure your company is fully registered properly, labor condition application, notice of posting, blah, 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 blah. There's like a lot of stuff we do in the 6 weeks that's required. So in order for us to start work, there has to be a company that can hire us, because the person getting the H-1B is not allowed to pay the law firm for any legal services. So you have to create your corporation or your LLC before you can hire us. And then once the corporation or LLC is formed, we don't want you doing anything that could be construed as work before your H-1B is approved. And the H-1B approval window typically takes 3 calendar weeks for the 15 business days of premium processing. So it depends on the fundraising environment and what type of company you're creating and how you're going to capitalize it. 3 years ago, when money was cheap, people could just raise 10 million bucks with a PowerPoint, as long as you had a sales founder and a technical co-founder, and you could get a VC meeting. So in those situations, people would have a chat with an investor for coffee and come out with a term sheet, and then instantly incorporate, do the H-1B, not code anything ever, give notice to their current job, get the H-1B approved, quit their current job, and then start at the startup. But that's not the environment we're in today. Over the last few years, many founders have needed to code their MVP and launch it to get traction, and also test pricing before investors are willing to entertain the possibility of investing in them. Therefore, there is this period that demands work prior to being able to raise venture capital funding. Therefore, many of our clients over the last few years have figured out other funding mechanisms like loans or personal investments or friends and family pre-seed rounds to get their startup off the ground, to transfer their H-1B employment to the startup, or to get a part-time concurrent H-1B in addition to their full-time day job, to be able to build a product and become investable. We can switch also from a part-time H-1B to a full-time H-1B. The other nice thing about having a concurrent H-1B is that if you get laid off from your day job, you aren't in a 60-day grace period, you're still in H-1B status. Now, the big concern with all of this is your intellectual property, because you want to make sure that there is a clean separation between anything new you create for the future company and what your current employer can lay claim to based on your current employment. So it's complex, and that is why there is no one-size-fits-all policy. How much money do you need to invest when taking the entrepreneurship route for the H-1B? It depends. No one-size-fits-all thing. If you want to have a 5-hour-a-week part-time concurrent H-1B and you want to fully fund it for the 3 years because you don't know if there's going to be any revenue to the business in those 3 years, then we figure out your hourly prevailing wage for the 5 hours a week. We multiply that by 3 years, and then you probably ought to put whatever $50,000 or something into the business before we file the H-1B. If you want to do full-time work and you need to make $150K a year for your prevailing wage, and then there's payroll taxes, and then you're also hiring other people, you might need north of $500,000. But in reality, most of our clients have between $50,000 to $100,000 in their bank account before we file the H-1B. And I've told this story before, but I've even gotten an H-1B approved for a company hiring 2 engineers at the same time that only had $8,000 in the bank account. There was an RFE, and there were letters of intent from enterprise software customers that were waiting for this product that were willing to pay as soon as the developers could reach the first milestones. So we were able to show that there was a real bona fide work opportunity there, and the H-1Bs got approved. As an entrepreneur and researcher with a PhD in STEM, would there be any changes in U.S. immigration policy that I should be mindful of? I'm outside of the U.S. at the present. My question is in the context of dramatic changes as we have seen in the past few weeks, of which has directly impacted us in access to research, resources, and collaboration with our American counterparts. Yeah, well, there is a lot going on with research funding. There's a lot going on with universities. There's a lot going on with immigration. So it's a lot. So far, high-skilled immigration seems to be remaining a priority for the United States, especially in critical and emerging technology areas such as AI. So if you are personally looking to immigrate in the future, I think you will continue to be in a good position to do so. If you are working with colleagues, this changing funding situation may affect what researchers are doing here. They may need to go to private research organizations instead of public institutions. Can a person on H-1B who has quit their job apply for an H-4 transfer and an O-1 transfer at the same time to hedge against the O-1A rejection? Yes. Because if you use premium processing, you will find out about the O-1 prior to the H-4 decision. And if the O-1 is approved, you can withdraw the H-4 transfer. So I think that works. Does opting for premium processing increase the chances of an RFE? Nobody really knows. Some people say yes, some people say no. I think it also depends on the officer that you get. We've been doing officer badge ID tracking for since last year in Alcorn, and there's just some officers that are going to give you an RFE, whatever happens. And then in that case, the best thing to do is withdraw and refile. A lot of my clients don't have the luxury of not using premium processing. So I don't have too many data points, but our really high success rate includes the vast majority of our clients always using premium processing. If I have an H-4 EAD visa, do I need to worry about my visa formalities at all, or should I directly start with the business formulation process? If you're in the US in H-4 status and you have a valid EAD, you are eligible for self-employment. Nothing further is necessary from an immigration perspective, and you can go about your business creating your company. Can I sponsor my H-1B with my startup if I don't have funding raised for it yet? Yeah, absolutely. We discussed earlier that there are alternative funding mechanisms, even letters of intent from future customers, but cash in the bank account is a better safeguard in case of an RFE that, as I mentioned, those amounts can vary and come from a variety of sources. If I'm an employee under OPT for the H-1B submission, there's a lot of questions. Okay, I'm gonna have to speed it up here. Okay, if I am an employee under OPT for the H-1B submission, from what I read, it has to be from an organization account. My CEO asked me to create the organization account and submit the petition myself. Would that be okay, since it's going to be from me to me, or does it have to be from her? I really think your CEO should do it. I think it could be compromised. There's no rule on this, but I think it could be compromising if you do it. So I would rather that, I mean, you could set up the account for the CEO and get everything ready. This is a service we offer if you would like to hire Alcorn to have your, be able to help your CEO with this. But there's like a submission button, and I don't think you should be the person submitting it, and you absolutely should not. I believe you should also not be the person paying for it, even though it's just $215. In case your company applies for H-1B, but you end up leaving the company before to figure something else out on F1 STEM OPT visa category, what are the risks in doing so and gotchas to consider? Well, you're going to find out by April 1st if you got selected. If you didn't get selected, you're free. If you get selected, then you have a choice. Do you want to stick around for 6 to 8 months and wait for your employer to file the H-1B petition by June 30th, wait for the approval, have it kick in on October 1st through a change of status, get 3 pay stubs, and then transfer to a new company? If you do that, you're going to have an H-1B. If you don't do that, then you risk never having the H-1B that you could have earned. So I think it's really just about like, how much do you want an H-1B? Because if you get selected in the lottery, most people would probably stick around to make sure they can get an H-1B. This person is an Indian citizen currently working in tech on an H-1B. Can I register a new business entity and grow it on the side while still working on H-1B at my current job without being a W-2 employee for the new role? No. Follow-up. Can I withdraw dividends from it? Maybe. In the future, I want to transition to my firm full-time. I understand that both H-1B and O-1 visas are applicable for me. In the scenario that I get an O-1 visa, would getting an EB-1A green card in the future become easier with the O-1A visa? Yes, there is a statement in the USCIS policy manual that says that the officers have to give deference in an EB-1A adjudication for an individual who previously got an O-1 approved. But to your main point, you can't like work on a company on the side without getting paid. I've tried to make it really clear when I was chatting more about this earlier, but work can be any activities in hope of future money. And so even if you're not getting paid, but you're hoping to make money or dividends from this in the future, you can't be doing those services. It's not about whether you can own a company that's profitable and creates dividends. Of course, you can own extra homes and you can hire a property manager to put it on Airbnb and you can just collect the money in your bank account, but you can't work there. Same thing with a tech project. Like you could own a company and there could be contractors that build everything and sell it, and you could just collect the money, but you're not supposed to be coding. So you have to be really careful about not violating the H-1B strictures on work authorization. There are no restrictions for an H-4 EAD holder in terms of what jobs they can do. But if you just have an H-4 and no EAD, then you're not work authorized. Will the L-1 get tougher after the recent TCS misuse news? I think that, let's see. That was 2 days ago. Look, I don't know. The one thing I know is that, Trump said when he was, that night he was signing all those executive orders in the White House, I think it was the night of the inauguration or the next day, about tariffs, that a lot of companies are going to need to be manufacturing and running their companies from the US. And what's the visa to do that? That's the L-1. So I think the L-1 is going to be a critical part of this administration moving forward to achieve their US manufacturing, economic, and national security goals. Follow-up question about EB2 and IW with banking for somebody working in regulatory and compliance in banking that aligns with US laws and acts and are mandatory for banks. Does that help? Absolutely, that helps. Yeah, we can have a deeper conversation about that. Okay, here's another question. Yes, you're welcome in advance. This person wants to open a company before CPT, wants to work for their own company and an external one while on CPT and OPT, and studies marketing and analytics, and the company sells 1 week long events program. Can it be related? Okay. They're starting an event company starting in May. They'll have CPT for an internship from August. They might have events and revenue on CPT and as an intern. And then when they graduate in December, they'll have OPT. Can you open the company before CPT? You can, but you can't work there and you can't plan anything or write anything or schedule any meetings or do any of the lead up. So it might be best to wait as long as possible to incorporate your company. Can you work for both your company and an external one while on CPT? No, your school has to authorize each employer for CPT separately. I don't know if your school will let you do more than 2 or more than 1 at the same time. Can you work for both your company and an external one on OPT? Yes, you can have more than 1 job on OPT as long as they're in your field. If I study marketing analytics and the company sells a 1 week long events program, can it be related to my field of study? Probably. And that would be something that you have to convince your school about. Okay. How the startup should be legally structured for applying for H-1B, is it different than O-1? There's lots of ways to structure companies, and I'm not a corporate lawyer, I just do immigration law, but I've seen my clients create LLCs as well as corporations. Their tax status is typically called a C Corp for startups in Delaware, but a California LLC, I don't, if it's majority owned by Americans, maybe it can have S Corp tax status. I'm not sure. There's lots of variations. For an O-1, your work doesn't necessarily have to be based on a company. If you file with an agent, you can get an itinerary of services, which can include personal contracting work. You don't necessarily have to have a company. But the company needs to be truly set up. And what that means from an immigration perspective is the legal structure exists, the addresses match, and ideally aren't related to your home and are ideally related to like 1 co-working space address for everything that's consistent. You get an FEIN number assignment from the IRS for your taxes, for your federal employer identification number. If you are living and working in another state than where you're registered, like if it's a Delaware corporation, but you have an office in San Francisco, you have to talk
you probably need to be registered with the California Secretary of State as a foreign corporation doing business here. And you probably need a bank account with money in it. And there might be other things too, like business licenses in your city or other types of licenses for your type of job. So we have a comprehensive checklist that we send to existing clients that enumerate those things in detail. So if you want to hire us, we would have a consultation to figure out, are we doing an H-1B? Are we doing an O-1? Which is best for your goals? Is there something else we should be considering? And then once we have focused in on the right trajectory, then we can onboard you as our client. And then we would share all those details with you. What about working on two different jobs, a startup founder and a fund manager? What's the best path, an O-1 or an H-1B? Well, both are possible. The O-1 is nice if you get it with an agent, because then you can have both jobs and other jobs just on one visa without getting an amendment. If you're on H-1B because you got it through the lottery and maybe you don't qualify for an O-1 yet, then an H-1B also works. We would get two concurrent H-1Bs, one for the startup and one for the fund. We would have to show that your job at each is related to your education and experience. And that can work. It can work either way. And the new thing there too is that even if you own 100% of your company, we can now get you an H-1B, but your H-1B will be valid for 18 months times 2 increments, and then subsequent 3-year extensions if eligible. Can I work while having CPT? This is at the discretion of your school, and they have to authorize it for you, but they have the power to, but every school has different policies on what they will actually allow. What are the risks of starting a startup while working at another company on an F1 visa on STEM OPT? And if one qualifies for an O-1 visa, what is the recommended way to do so? Does not having a prior O-1 visa become a problem, or not having the funding secured become a problem? Well, it's a big problem if you work without authorization, because then you violate your status. So you want to get the correct work visa prior to engaging in any work. Funding is not necessary to qualify, although if founders do have funding, it can make the O-1 process easier, but it's not a necessary, it's unnecessary. You can fully qualify for an O-1 without having raised funding. So the biggest risk is working without authorization, and you should figure out a plan to get the right visa as quickly as possible. Can a product advisor / board for a friend's startup while on H-1B full-time job? I just need a minute here. Oh, can I be? You want to advise a friend's startup about their product and serve on their board while on an H-1B with a full-time job? Okay, so I've looked at this before no, and that's the reason why a lot of people want O-1s. Because if you're getting paid advisory shares for the advising work, what you should have is a concurrent H-1B, which also requires a prevailing wage. And so a lot of startups aren't willing to do that for the board advisor. So yeah, this is a big reason why many of my clients have wanted O-1s over the years. What are common pathways available for engineers working on crucial technology in the financial services sector to gather letters of evidence to prove critical role? It's really based on your projects and what you invented and what you created and why you've influenced your field and how you've disrupted financial services engineering and what's the crucial technology and how did you advance the field and why are other people doing things in your field differently now as a result of your work? How did you affect other professionals in your field? That's really what we're going for. Can a CAP subject H-1B be transferred to a CAP exempt H-1B and then back to a CAP subject H-1B without going through the lottery process? Yep. So I don't know why you would do that. It doesn't really matter. Each employer would just check a different box on their H-1B petition for you. As long as you've been through the H-1B once through the lottery, you get 6 years. So maybe if you're trying to save time before you have a perm or an I-140, then yeah, then you could do that.
Is it possible? Actually, though, I think the rule is that you can have up to a total of 6 years. You know, that's a technically nuanced question. So that would be something where your employer ought to have a call with you and me to determine your eligibility. Is it possible to teach at a university while keeping your H-1B full-time job? If it's unpaid, as a hobby, but even some lawyers who are more conservative than me say no unpaid volunteering work. I don't think it's that critical, but yeah, you certainly can't get paid to do that. How do you usually work to waive the 2-year rule for Fulbright scholars and or make them come back to the US temporarily? Yeah, you can't. The 2-year Fulbright rule, it's like the one I've heard of from a school DSO at a top university in 30 years in their career. They knew of one, and the only reason they got the 2-year rule waived was because the Fulbright scholar's spouse had cancer and the only treatment was in the United States. Very hard to get out of this. I help a lot of doctors out of Stanford Medical School who are Fulbright scholars and subject to the 2-year 212E, and they're on an O-1 working as a physician here. And they literally like go back home every summer for 3 months on a sabbatical, and they slowly fulfill that over time, but you have to go back to your home country. Fastest would just be go back home for 2 years, but there's really no practical way out of it. I mean, maybe if like the military would write you a letter saying that they need you, maybe that could work. Can I please break down the work being directly related to the area of study rule for the F1 OPT work? I'm concerned I might get an RFE for this, as I've gone into a role that most graduates from my degree program don't go into, but I do apply my skills from my program. If I do get an RFE, how best to deal with it specifically for this case? Well, you're welcome to contact us and we'll see if it's something we can help you with. But in general, you can look at the requirements for your degree as well as your transcript and connect the dots about how you have the right education to get these skills. What kinds of documentation are required to prove exceptional ability to self-sponsor the EB2 NIW green card? There's a list of categories that's vaguely similar to the O-1, but a lot easier. And it's things like, do you have a degree in your field? Do you have 10 years of experience? Do you have licenses or certifications in your field? Have you gotten honors in your field? So there's a variety of things. Sometimes we just use the O-1 requirements as well and apply them and kind of like shove an O-1 into an EB2 NIW weirdly. So it's very flexible, but you can reach out for a consultation and I'll be happy to help you assess your possibilities. What would I advise someone who's currently pursuing H-1B sponsorship in an industry that does not tend to sponsor, i.e. publishing? Good luck. I don't know. Maybe if you find the right person, they'll sponsor you. Maybe a startup will sponsor you. It's very difficult to convince an employer to sponsor you if they don't already want to do it. So you get one chance in the lottery from one employer, so you only need one employer to sponsor you. And the lottery closes March 24th. So that's your timeline. Maybe also consider careers in other industries or consider creating your own company. Maybe you want to do publishing consulting work and you want to create your own company for that. And maybe that could put you in the lottery. My company is currently filing my EB3 I-140 after my perm got approved, but there's some risk of layoffs and my priority date is October 2023. What are some strategies I can do to buy time in case of a layoff or keep my EB3 going? I talked to one client recently in this position, and the company, instead of a severance, offered a longer duration of employment to delay the starting of the grace period. And the company also agreed to keep the perm active and to allow the I-140 to proceed. They were not going to withdraw it. So those are things you can ask for. Okay, how are we on time? Got 8 more minutes. And then what am I doing next? Literally going into back-to-back consultations. Okay, so we're gonna have to definitely wrap up on time, but
I will just say, as we round this out, the QR code helps you book a consultation with me. One of the reasons I'm offering this AMA is because my life goals would be to help as many people as possible, but I can't grow my firm as fast as people are asking for our help, which I feel very blessed to be in a position to serve people like that. But it means that we have limited capacity to help people who are requesting our help. I have limited capacity for consultations. Because people have had to wait, that is one of the reasons why we wanted to schedule this AMA last minute. So I really hope it's helpful. If you would like to have a consultation with me, sometimes my team will tell you, please take Sophie's complimentary online class, Alcorn Academy. It's 15 video modules. It'll help you become prepared for your O-1A, EB-1A, or EB-2 NAW. So that means that we think you're not qualified yet. And if all you put in your questionnaire is that you want an O-1 and you don't seem qualified, then we might send you to Alcorn Academy, and I'll give you that link right now. I made it a couple years ago. It's an evergreen course content structure. And over the holiday, we decided to make it complimentary, and 1,000 people have now done it. And somebody from like IIT and MIT and Harvard told me they thought it was awesome. So I was very gratified by that compliment. So that's available for all of you. I just put the link in the chat window. Another thing my team might offer you is our other offering called Legal Launch. And this is something I made because I would love to help everybody become more qualified and give them personal consulting and advice and coaching, but I don't have the bandwidth. And so I've done this over the years, but I turned it into a 4-week evidence assessment and analysis program where you work with our team, you have a series of meetings, we give you our 20-page checklist, you upload all of your stuff, and we do our 3-layer internal case strategy review. And then we have a case strategy meeting where we identify any gaps of being fully qualified and where you're at now. And then we help you create a personal checklist of additional evidence to accomplish. And Alcorn Academy is $2,500. And if you become qualified for an O-1A, EB-1A, or EB-2 NAW within 6 months, and you want to hire us, we'll fully credit the $2,500 to your future case. So if you get one of those emails from our team, it's not that I don't care about you, it's that I truly think this is the best way for us to help you. And I really want to take care of you and I want to help everybody. And I just don't have enough hours in the day right now, but I'm honored to be of service and I hope this is helpful. Okay, so a few more minutes, lightning round. How one finds an agent engineering for an O-1 visa. You hire us and we introduce you to one. If one gets an O-1 engineering visa via an agent, can he or she do freelance work for any company without additional paperwork? Yes, if you hire my firm, because that is how we will draft your O-1. Somebody's in the first year of F1 OPT, how to best prepare for an O-1 or EB-1 visa, avoid the lottery. Does working with AI give special benefits? Yes. Are there any other visas you should pursue? Possibly. Any best practices, tips, or tricks? Check out Alcorn Academy. Link is in the webinar chat. Can I open a company before CPT? Maybe, but it's risky. We already answered these questions in once, people. Okay, for the O-1, is it harder for a Chinese citizen to get that? Potentially, but not in terms of like how extraordinary are you, but maybe in terms of the visa processing. But we can still absolutely help you with that. For someone on STEM OPT in a cap exempt position, when would you recommend starting the H-1B application? Apply every lottery. And if you're going to do this year's H-1B lottery, hire us now because our prices are going up by $2,000 per person on March 1st. But we still have our normal pricing of $2,200 for the lottery in the month of February. And the whole H-1B, we charge $5,000 to $6,000. Plus about $4,000 to $5,000 for USCIS, so it's about 10 or 11K, and we credit the 2,200 from the lottery to the future petition. Is it too late to open a new company to sponsor yourself to join the H-1B lottery now? No, I think you have time. You can do it. If my startup failed and I have less than 12 months on STEM OPT and I have one H-1B attempt left, what would you recommend as my potential options if I want to stay in the US? Get a job. and get them to put you in the lottery and use that for your OPT, your STEM OPT, and try to become qualified for an O-1A. What are some common disadvantages with an O-1 visa that are often overlooked by the prospective recipients? Does the O-1 visa need to be extended every year? It is quasi dual intent. It is not full dual intent like an H-1B. Your spouse on O3 can never work. And it is now 3-year extensions instead of 1-year extensions. Is there a pathway from an E2 visa to a green card through EB2 NIW? Absolutely, yes. Can an F1 visa student open an LLC while working on internship, CPT, or OPT? Yeah, if you just own an LLC and you don't work there, that's totally fine. Does the part-time H-1B and the full-time H-1B need the same job? Is it the same job title? Is it a different job title? Basically, you just have to consult with us, tell us your business plan and what you're trying to do in real life, and then we'll make sure that the H-1B stuff matches your reality and your desired goals. The new rules for the NIW filing, if you go onto the USCIS website and you read the policy manual for EB2 NIW, you can read about the new standards. They particularly apply to researchers and entrepreneurs, and I put the link in the chat window. Can I do a part-time H-1B with my nonprofit foundation concurrently with my full-time H-1B? Yes. Is it advisable to set up a US subsidiary of an existing startup in Australia to create a pathway to be an entrepreneur on a suitable visa to be based within the US? I have a PhD in STEM. If you're Australian, you qualify for an E3 visa, an E2 investor visa, and an L1 visa, in addition to the H-1B and the O-1. I just learned that the H-1B is valid for only 6 years and one has to leave the country for 1 year before applying again, but I don't think this is what happens in reality. What do most people do in this case? You have to get a company to file a perm for you, or you have to self-petition an EB2 NIW, and you need the I-140 approved, and then you can get unlimited extensions of the H-1B beyond 6 years. Okay, everybody, that was a record. So many questions. Thank you all so much. Our team will be reaching out and we'd be delighted to help you with any remaining questions, but thank you and have a wonderful rest of your day. Really appreciate all of your attendance, support, and amazing questions. Okay, everybody, bye.